Within the framework of parliamentary democracy and federalism, judiciary plays an important role in the governance of the country. The judiciary is an indispensable part of governance, and an efficient and independent judiciary is the greatest guarantee of well-being of society. Indeed, the Indian judiciary was seen to be an arm of social revolution, upholding the equality and dignity of men that the people of India suffered long during the colonial days. But it has not been gained as yet. Yellowed 1999, historically speaking, the Indian judicial system has had a glorious past. Most of our freedom fights have been from legal profession. The presence of leaders like Mahatma Gandhi, Motilal Nehru, Dr. Rajendra Prasad, Sardar Patel, K.M. Munshi, M.A. Jinha, Gopal Krishna Gokhale, Bal Gangadhar Tilak in the struggle for independence, all of whom belong to the legal profession, showed that they were aware of the need of us for a strong judicial system in India. The framers of the Indian Constitution conceived of a judicial system which was free from the control of the executive as well as the legislature. India opted for a single judicial system, and by creating a single judiciary with the Supreme Court at the top, the framers of the constitution obviously intended to introduce certain judicial reforms. In the governance of democracy, the judiciary plays a very important role, which is second to none. The constitution accords a place of pride to the judiciary by conferring the power of judicial review of the legislative and administrative actions and entrusting it with the task of enforcement of the fundamental rights guaranteed under the Constitution. In fact, the judiciary assumes a significant and spatial importance by virtue of its very task of sitting on judgment on the actions of the other two organs and power of interpreting the constitutional provisions. Judiciary. The organization for giving justice to the society occupies a position of preeminence among the three organs of the state. Justice is considered as a logical requirement of any society, for it is a part of human nature to expect justice and be intolerant to injustice. Justice enjoins upon everybody to preserve the basic order of society and prohibits everyone to disturb it. Independence of judiciary. The promotion of good governance through judiciary depends on its independence to a great extent. An independent, unbiased, and able judiciary is the first requirement of justice. Independence of the judiciary means independence from the government in power, since judges have to provide justice not only between citizens but also between a citizen and the state. The Indian Constitution makes provision for an independent and impartial judiciary. Justice Chandrachud opines that the independence of judiciary is the cardinal feature and observed that the judiciary, which is to act as a bastion of the rights and freedom of the people, is given certain constitutional guarantees to safeguard the independence of judiciary. Kumar Bhatia, 1999, Justice Bhagwati observed that the independence of judiciary is a fighting faith of our constitution. Fearless constitution is a cardinal creed of our founding document. In order to ensure the independence and impartiality of the justice, certain provisions are provided in the constitution. One such provision is the appointment of judges. The constitutional provisions regarding the appointment of a judge is that only those persons can be appointed as a judge of the Supreme Court who are citizens of India and has been judge of a high court or of two or more courts in succession at least for 5 years, or has been an advocate of a high court or of two or more such courts in succession at least for 10 years, is a distinguished jurist in the opinion of the president. These provisions show that no ordinary person can become a judge. In other words, highly qualified persons can become a judge of the Supreme Court. In the lower courts, appointments are made on the basis of written examinations. Those who clear the examinations are appointed. Here too, we see that the appointments are strictly made on the basis of merit. Secondly, they are provided security of tenure. Once appointment, they can stay in office till they attain the age of 65 and 62, Supreme Court and High Court respectively. They can be removed from their post only on the ground of proved misbehavior or incapacity through a process of impeachment. So this impeachment process is so tough that till date, no judge has been removed from the process from the post. Once the proceedings were initiated against Justice Ramaswamy for financial irregularities, but the resolution could not be passed for want of required support in the House. Thirdly, in case of Supreme Court judges, they have been prohibited from practicing law before any court of authority within the territory of India after retirement. Fourthly, they are paid handsome salary and entitled to a free house and certain other allowances and privileges. Neither the salary allowances and privileges nor their rights in respect of leave of absence or pension can be varied to their disadvantage after their appointment. During a grave financial emergency, the salaries of the judges may be reduced. Fifthly, all the actions and decisions of the judges in their official capacity are immune from criticism. Besides, the conduct of a judge may not be discussed in the parliament except when a resolution for his removal is before it. Finally, the Supreme Court has been authorized to have its own establishment and to have complete control over it. It is further authorized to make appointments of officers and servants of the court and determine their service conditions. All these provisions were made in order to ensure the independence and impartiality of the judges. As Ambedkar said in the assembly, it was the intention of the framers to create a judiciary and to give it ample independence so that it could act without fear or favor of executive or anybody else. Paley 2001. Speaking on the draft constitution with regard to the judges of the Supreme Court, the then Prime Minister Jawaharlal Nehru opined the same. He observed, it is important that these judges should be not only first rate but should be acknowledged to be first rate in the country and of the highest integrity, and if necessary, people who can stand up against the executive and however may come in their way. Varma 1996. A similar view regarding the independence of judiciary was expressed by H.R. Gokhale. The then law minister, while speaking in parliament, he observed that the government is very keen and will see to that India will have a strong and independent judiciary and the judges will function according to their oath without fear, ill will, affection, or favor. Verma opts it. Role and functions of Supreme Court. The constitutional task assigned to the judiciary is no way less than that of other two functionaries, legislature and executive. Indeed, it is the role of the judiciary to carry out the constitutional message, and it is its responsibility to keep a vigilant watch over the functioning of democracy in accordance with the constitution. Sir Aladi Krishna Swamy Iyer remarked in the Constituent Assembly that the Supreme Court under the Constitution has wide powers more than the highest court in any other federation. The criticism, if at all, can only be that the powers of the Supreme Court are not wide enough, but that they are too wide. Constituent Assembly debates 1949, the various roles and functions of the Supreme Court are discussed below. Original jurisdiction, Article 131. This refers to the cases that directly originate in the Supreme Court. It has original exclusive jurisdiction in any dispute between the government of India and one of more states, or the government of India and any state or state on one side and one or more state on the other, or two or more states. Appellate jurisdiction, Article 132 and 136. This refers to the power of reviewing and revising the orders of power courts and tribunals. This jurisdiction extends to both the civil and the criminal appeals from the high courts under certification from these courts or in its absence permitted by the Supreme Court itself. Normally, these appeals are in cases involving substantial question of law of general importance of or interpretation of the Constitution or death penalty awarded by a High Court. Advisory jurisdiction. Under Article 143, the Supreme Court has been vested with the power of advisory jurisdiction. Whenever the President consults the Supreme Court on any matter of public importance, it gives opinion to the President. The Supreme Court may also decline to give its opinion to the President. The advice is not binding on the President. Supreme Court as a court of record. According to Article 129, the Supreme Court shall be court of record and shall have all powers of such a court, including the power to punish for contempt of itself. As a court of record, it has the power to punish those who are adjudged as guilty of contempt of court. Appeal by special leave. This power has been conferred upon the Supreme Court by Article 136. It may, in its discretion, grant special leave to appeal from any judgment, decree, determination, sentence, or order in any case or matter passed or made by any court or tribunal in the territory of India. Writ jurisdiction. The Supreme Court is the guardian of the individual liberties and fundamental rights. It has the power to declare a law passed by any legislature null and void if it encroaches upon the fundamental rights guaranteed to the people by the Constitution. For the encroachment of fundamental rights, it can issue writs in the nature of habeas corpus, mandamus, certiorari, prohibition, and quo warranto. Judicial review. Besides the above mentioned powers, the Supreme Court has the power of judicial review. It implies the power to review and determine validity of a law or an order. It refers to the power of a court to inquire whether a law execute order or other official actions conflict with the written constitution, and if the court concludes that it does, to declare it unconstitutional void. Singh 1994 opines that judicial review in India is based on the assumption that the constitution is the supreme law of the land and all governmental organs which owe their origin to the constitution and derive their powers from its provisions must function within the framework of the constitution and must not do anything which is inconsistent with the provisions of the constitution. However, the Indian constitution does not in so many words assign the power of judicial review to the court. There are several specific provisions in the Constitution which guarantee judicial review of the legislation, such as Articles 13, 32, 131, 136, 143, 226, 145, 246, 251, 254, and 372. Apart from these articles, the power of judicial review is derived from the position of Supreme Court as the guardian of the Constitution. The court can challenge the constitutional validity of a law on the following grounds. The subject matter of the legislation is not within the competence of the legislation which has passed it. It is a repugnant to the provisions of the Constitution, or it infringes one of the fundamental rights. The power of judicial review in general flows from the powers of the court to interpret the Constitution. As such, it has finally say in the interpretation of the Constitution, and by such interpretation, the Supreme Court has extended its power of judicial review to almost all the provisions of the Constitution.